Okay, thank you very much, Eva, for the kind presentation. Thank you to Igor for the kind invitation. And it's always a pleasure to come to Dubrovnik. It's a great honor for me to like to speak here. As you can see, and Eva has told you, I'm going to speak about jurisdiction competition in the air transport sector, basically extraterritoriality of the airfreight, which taking into account that we've been talking about maritime law or one morning, what's perhaps an extravagant proposition, but I think if you exchange air transport sector by maritime transport sector, the outcome is exactly the same. That I think it may be also an interesting input for you, and I think the topic is relevant because the general court has just delivered a series of judgments on this issue, which are really very interesting, and I would like to talk about that. So I'm going to speak about jurisdiction and competition, or as I call it, the art of the war against the fraud. I plan to do this by using a practical example, which is that of the Airfreight cartel. I will briefly explain in which it consisted, then we will speak about the material and territorial scope of the Commission's jurisdiction over time and the extraterritorial or extraterritoriality in the Airfreight cases, which are the problems. So we'll have a quick look at the foundations of extraterritorial application of competition law to decide whether these criteria in order to apply extraterritorially competition law are fulfilled in this Airfreight case. After some concluding remarks, I may have the time to address briefly other tactics to tackle with competitors harm in an international frame. So why do we discuss extraterritorial application of European law? Well, Sun Tzu allegedly said, I don't know any Chinese, so perhaps it's a gift that with noodles, but I hope that we have to check in which army is there greater constantly punishment, that is, on which side is there the most absolute certainty that misdeeds will be summarily punished. And to summarily punish and competitive misdeeds, on occasions we will have to apply competition law extraterritorial. As a theory, I'm going to use an example, which is that of the Airfreight cargo case, which probably began in 1999, and it was discovered in 2005 under an application for immunity under the then called leniency later of the European Commission. As soon as their knowledge of the enemy's dispositions can only be obtained from other men, and hence the importance of leniency. This decision, so it was discovered, the Commission then issued in 2010 its first decision. It fined 15 addressees for single and continuous infringement. The decision, is tackled, or it had to tackle, with a price-fixing cartel between 15 cartelists, which referred to fuel and security surcharges, and it also aimed at denying remuneration to trade forwarders. The decision was quashed in 2015 by the General Court, but it was quashed on procedural reasons I will not address. So the Commission issued a second decision in 2017. There are only 14 addressees left still a single and continuous infringement, and they are left addressing the fine is also a little less. Some of the controversial issues in this case, in the Airfreight case, refer to the jurisdiction of the European institutions, which is what I'm going to speak about in the next 25 minutes more or less. So the first thing we should analyze is, what does jurisdiction mean? And if we have a problem with interpretation of words, the usual recourse is the dictionary. Oxford Learned Dictionary tells us that well, jurisdiction is uncountable or countable. That noun, which means the authority that an official organization has to make legal decisions about somebody or something, which is precisely what I'm going to talk about, the authority of the European institutions to make legal decisions, that is, to impose a fine on somebody. Well, these controversial issues regarding jurisdiction mainly address two problems. The first one is the material and territorial scope of the Commission's jurisdiction over time, which depends on internal provisions, that is, provisions of the European Union, which define the jurisdiction of the Commission. And then there is the extraterritorial application of European law, which is not an internal question, but it's a question of international public law. Well, if you have to look at the material and territorial scope over time, I don't want to bore you with this question because you probably know that in 1962, Regulation 141 decided that well, the competition law in Article 101 and 102 does not apply to the transport sector due to the peculiarities of this sector. And in the air transport sector, it was not until 1988 that the Commission did have jurisdiction to investigate and to find competitive harm. In 87, Regulation 3975 did confer power to investigate competitive misdeeds to or on the Commission, but it only did so regarding international transport between community airports. So it's a very narrow jurisdiction, only transport between European or community airports. Then in 2004, this was changed by a regulation we will have the occasion to talk about later. From then on, the jurisdiction now refers to routes also between EU and third country airports. I've highlighted only the provisions that refer to flights that depart from or are headed towards airports of the EU, but the decision also analyzed flights from or to the European Economic Area or Switzerland. The extraterritorial application of Europe is definitely a more tricky question, and what we are going to ask is whether the Commission has jurisdiction under international public law. And what you might know, that there are two traditional criteria which do provide jurisdiction, which is the principle of personality and that of territoriality. Personality probably is not so important, but it's that a state has jurisdiction over its national, although they find themselves abroad. That is, since I'm German, German authorities know prosecute me, although now I'm living in Spain. More important is the principle of territoriality, which says that a state has unlimited jurisdiction over the state territory, including for nationals who merely reside or temporarily find themselves therein, which would be my case in Spain, because I do temporarily reside therein. What then is extraterritoriality? What by exclusion, extraterritoriality is jurisdiction over acts which have been committed by non-nationals abroad. And this is what we are going to speak about. In order to adequately address the question, we should mention that there are two further principles which derive from the principle of territoriality, which, as I told you, is the most important principle as regards jurisdiction. The principle of subjective territoriality said that a state is allowed to deal with acts which originated within its territory, but which are completely abroad, and more importantly, the principle of objective territoriality, which says that a state is allowed to deal with acts which originated abroad, but which have been completed, at least in part, within its own territory. But what does completed mean? Doesn't they have jurisdiction where acts of foreign nationals committed abroad, extraterritorial agreements, have effects, mere effects, in the investigating state marketplace? In the US, the others, based on a very old doctrine is called the effects doctrine, and well, to the European version of this effects doctrine, I will have the opportunity to come back later. But what happens in the Airfreight case? Why do we have to address the question? Well, I already told you that there were 15 addressees, and 6 of them are non-European airlines. And these non-European airlines perform cartel-like transactions, that is, they included contracts for the carriage of goods by air with third parties who are not national of the European Union or the European Economic Area or Switzerland. And they did so outside the EU, and there's the problem. Susanna in her lecture this morning spoke about accidental jurisdiction, and this is precisely the problem here. All criteria are situated outside the European Union, and what we are trying to do is attract jurisdiction to the European Commission. So how can we do this? Does the Commission have jurisdiction to investigate the case? In order to answer the question, we arguably have to distinguish between enforcement jurisdiction on one hand and prescriptive and curial jurisdiction on the other hand. This distinction has been established for the first time by the Court of Permanent Justice, a very important judgment of 1927. I don't have the time to explain the case to you, but it basically boils down to the question as to whether Turkey had to be able to point to some type of jurisdiction to investigate in a criminal case which implied involuntary manslaughter on the high seas, whether it had to be able to point to some type of jurisdiction recognized by international law, or on the contrary, whether Turkey was allowed to exercise jurisdiction unless such jurisdiction came into conflict with an already recognized principle of international law. Well, the Court of Permanent Justice in the end adopted the second view in its decision in the Lotus case, and well, it said that enforcement jurisdiction usually is impossible because the state may not exercise its power in any form in the territory of another state, which is a principle you perfectly know. I mean, a Croatian tribunal can hand down a decision, but if you have to enforce it raw, we have to ask the enforcing state to do so. Croatia could not do this. But it also said that regarding prescriptive and curial jurisdiction, states have a very wide measure of discretion, and it is only limited in case there is an international principle which prevents a state from exercising prescriptive or curial jurisdiction. So, states have unlimited prescriptive and curial jurisdiction. Well, the answer obviously is no. Professor Patrick spoke about this yesterday when he spoke about the UNCLOS. There has to be a genuine connection, a genuine link, and an effective link, however you might want to call this. This is so because the International Court of Justice said so. And it said so in a case with, or in 2 cases which have admittedly nothing to do with either competition or even punitive law, but this is a generally accepted principle today. But when is there such a genuine link, or however you would want to call this? Well, within the European Union up to now, there are three different theories which explain the existence of such a link. And the first opportunity in which the Court of Justice had to deal with this question, well, actually, the second opportunity, but the first important opportunity on which it did so was in its 1972 decision in the direct class. Okay, here the Attorney General said, okay, we should follow the US approach and apply a facts doctrine, but the Court of Justice said, no, we don't. What we do is apply a single economic entity doctrine, which is basically based on corporate relations between offenders within and outside the common market. The second important case is Woodhull 1, 1988. The Advocate General again said, please effect test. The Court of Justice said, no, don't. And it established yet another doctrine, which is that of the implementation. It said that, okay, we have to distinguish between formation and implementation of an agreement. It does not matter where an agreement is formed. So, I mean, parties could just go to I don't know, to South Korea to conclude an agreement if this would prevent competition laws to be applied, but this obviously cannot be so. So formation is irrelevant. We have to look where the agreement is implemented. And in the Woodhull 1 case, the cartelists did sell their products to consumers within the common market, and so the Court of Justice held, well, the agreement has been formed abroad, but it has been implemented within the single market, so there is jurisdiction the Commission can find the offenders. The last case is Intel, which was handed down in 2017. But you should know that Intel is not a cartel case. Intel is a abuse of government position case. So the findings are not necessarily applicable to a cartel case. And the Intel case is tricky because, or was difficult by the time, because there were some agreements signed by Intel, which have been concluded with a Chinese company. They refer to CPUs that have been manufactured. And so outside the territory of the EU, and they were to be incorporated into computers manufactured in China. So all criteria, once again, situated outside the common market. In first instance, the General Court did apply the qualified tax test, so neither implementation nor economic single economic entity, but qualified facts, which means that there have to be foreseeable effects, there have to be direct effects, and there have to be substantial effects within the common market. That is, there has to be a genuine link. The agreement or the conduct has to be completed within the common market. I will come back to these foreseeable, direct, and substantial effects later, but I should perhaps tell you that the General Court also assessed whether the conduct was implemented within the common market, but it did so only for the sake of completeness. So it did hold that effects is enough, is sufficient. We do not need implementation in order to establish jurisdiction of the Commission. On appeal, the Court of Justice upheld all and every single one of the arguments, which is quite surprising because up to that day it had gone to very great length to not to apply the effects test. And it even says that the qualified effect test pursues the same objective as the implementation test, which is preventing conduct which, while not adopted within the EU, has anti-competitive effects liable to have an impact on the EU market. So these are alternative tasks, we do not have to take implementation in order to establish jurisdiction. So what happens in the Airfreight case? Are the conditions for extraterritorial application met with regard to inbound flights? Inbound flights really is a problem. I explain you why. If we have a quick look at the implementation test, I told you that an agreement is implemented when the cargo sales are made directly with buyers established in the common market. But this is very difficult to establish for inbound flights because customers that purchase air freight transport services are in general established within the country of departure. If you imagine an Australian airline, well, its customers will be based basically in Australia. Then the sales of air freight transport services are usually made by local personnel of the airline or local sales general sales agent within the country of departure. So the contract of carriage is also concluded in Australia, and the prices for air freight transport services are generally expressed in the currency of the country of departure. So currencies would also be Australian, and sales of air freight transport services, including these surcharges, are in general regulated by authorities in the country of departure. So all relevant criteria are situated outside the European Union. Then in order to fulfill this implementation test, we could say, okay, internal regulation, which is Regulation 1/2003, after amendment in 2004, says there's no distinction between inbound and outbound flight, which is probably true. It's still pending before the Court of Justice. It's probably true, but it is not decisive for the Commission's external jurisdiction. It doesn't matter. Then many of the contacts is also true between the adjustments have taken place in the European Economic Area or involve participants established therein. It is true, it was true, but as we know, unless the agreement affects trade between member states to implement it within the EU, the place where the agreement is concluded is irrelevant. And then the services affected by the agreement are partly provided within the territory of the EEA, which is necessarily true, and the flights are habit port and airport within the European Union or the EEA. But this does not mean that there necessarily is an affectation of competition within the common market. And then there's the last possibility, which is quite far-fetched. We could think that the cargo has been implemented by the cargo list customers within the EU, which is one of the tests in Intel. But as I said, it's very far-fetched, and I think in this case, this is utterly impossible. So if implementation poses lots of problems, the easier court is qualified facts. And this is an easier court because I think that facts on European territory cannot be denied, because of course if transport is more expensive, this arguably means that the products which are transported are also more expensive. So there almost necessarily will be effects within the European Union. But are these effects direct, substantial, and foreseeable? With respect to direct effects, this is quite difficult because the effects of consumers within the European Union is not on effect. Transport services are not sold to end consumers in the EU, but they are sold to freight forwarders. So really, they're just not on effect by passing on the surcharge to the end consumers. But there may be immediate effects where the freight forwarder who buys transport services is established in the common market or when he acts on behalf of a buyer in the EU. Then the effects also have to be substantial. I already told you this was a single and continuous infringement, so this probably would not pose a very big problem and the effects also have to be foreseeable. And I think that a foreseeable criterion is better than that of directness. We've already spoken about accidental jurisdiction, and the other case is the same. What we want to prevent is that actors are surprised applying foreign laws, the application of which they could not foresee because the number of intermediary factors is too large. And this is why the General Court, when it addressed these questions, it started with the foreseeability of these effects. I will come back to this later. So what does the General Court think? It had to address this question that I already told you in March 2022. In all these decisions, the fundamental questions are the same, but the addressees, the appellants, raise different questions, so the judgments are not exactly the same. There are questions which are addressed in some judgments and in others they are not. I will focus on the first judgment, Martin Air, 328, 2017, but there are some particularities in other judgments I will also address. These judgments are important because it is the first opportunity the court had to rule on extraterritorial application after Intel, the first opportunity to rule on jurisdiction regarding services, and the first opportunity to rule on Intel effects test in a cartel case. Although it's not exactly true because there's a 2018 judgment we've already referred to extraterritorial application and a cartel case. But on this occasion, the General Court did not rely on Intel, which is 1 year older, which is quite surprising. It relied on a previous judgment of 1971. So we already know that the implementation and the effects test are alternative approaches, so we do not have to prove implementation with having effects is enough. We also know that there's no need to prove actual effects. The court said so in Intel. And we also know that qualified effects test allows the application of competition rules when it is foreseeable that the conduct an issue will have an immediate and substantial effect in the coming month. Starting from there, the General Court distinguished between effects of coordination in relation to inbound freight services taken in consideration. There is only the question of inbound services, whether the Commission has jurisdiction or not, an effect of a single and continuous infringement taken as a whole. So regarding the first question, inbound freight services taken in isolation, we first analyze whether we really do need the facts. And it says, yeah, of course, we do need the facts, although in this case it was a restriction by object. Under internal competition law, if there's a restriction by object, we do not have to do the facts. But we are here talking about jurisdiction. And to establish jurisdiction, you have to establish the existence of the facts. But this is enough with probable effects. And here there are probable effects because the goods are imported arguably at a higher price into the common market. It then assesses foreseeability in the term that, well, okay, experience says that whenever there is a price fixing cartel, this leads to higher end consumer prices, which is quite understandable. So there is foreseeably there will be the facts. It also analyzed the so-called waterbed fact, which says that, okay, perhaps these higher surcharges are then set off by lower rates and charges. But where there were two problems. The first, freight forwarders had also entered into a price fixing cartel, so we do not really know which the rates would have been. And on the other hand, it was not proved by the applicant. And then it was also foreseeable that these surcharges would be passed on to end consumers. Therefore, the substantiability of the tax, it said that all circumstances have to be taken into account: duration, nature and scope of the infringement, proportion of the price of the finished product represented by the cartel line service, and here the duration was quite long, and the part of the price affected by the cartel was quite high, and the market share of the participants in the cartel was quite high. Regarding immediacy of the facts, which was, as I told you before, the tricky issue, well, here the court said that, of course, we do not have to take into account all the facts, however remote, which are contiguous in one norm. It would be absurd. The textbook example is that an ironmonger who sells a knife, and this knife is later on used to murder a person. Obviously, the sale is a contiguous sine qua non, but it is not relevant to establish causality. So the idea is saying we have to establish adequate causality. Only those questions which really adequately contributed to the result. But that means that even if there are intermediary factors, a third party, in this case, the freight forwarder, does not necessarily raise the chain of events. So to speak about direct or immediate effects probably is not too adequate, because I mean these are indirect effects, but the cartel is adequately causal. I will skip this slide which refers to the single and continuous infringement. You have 2 minutes. 3. And we'll briefly address some other questions addressed by the courts. First, we have to distinguish effect on trade between member states, which is the substantial condition to prohibit a cartel, and qualified facts in order to establish jurisdiction. Then, even in cartel cases, we normally have to investigate the relevant market, but it is not necessary when there are no doubts as to whether the conduct restricts competition in the internal market and affects trade between member states. It also said that this is also quite important, the effects as to jurisdiction do not necessarily have to occur on the same market as that concerned by the infringement, so the market for the sale of goods and the market for period of services, and more importantly, the facts need not lead to conflicts of jurisdiction. If effects are enough, it's perfectly possible that one same cartel is filed in the European Union, in China, in the US, and in Australia, where this usually is not a problem, because what we are sanctioning is the effects of the cartel within the jurisdiction of the court. So, 2 or 3 concluding remarks. The judgments are important. They consolidate the effects test, but all those judgments have been appealed before the ECJ. So probably within 3 or 4 years, I can come back and speak about this same problem when the ECJ has handed down its ruling. I already told you I have to distinguish the facts as a substantive rule and effects to exercise jurisdiction. And one last question: is this really all necessary? And I'll finish with this, because if you have to look at the United States, the Department of Justice and the Federal Trade Commission say that conspiracy between 2 foreign shipping companies, this is maritime law, but it is also relevant for air law. A conspiracy between 2 foreign shipping companies to fix the price of shipping services, which are closely connected to the importation of goods into the US, is conduct involving import commerce. So we do not have to look at qualified effects, but we apply the general test of effects on commerce. And this seems to be what happens also, for example, in Switzerland. In the EU, it's a bit more complicated. So sorry for using 3 more minutes than I had originally allotted. And many thanks for your attention.